A very good evening, dear. So, are you appearing for the first time?
Yes,
Okay. Which state do you belong to? Himachal only?
yes, ma'am. Himachal.
Okay, okay. So,
Himachal
what
Pradesh.
motivates you to become a judicial officer? Like, what is there? Why do you decided to choose this career?
Ma'am, I always wanted to do something to dedicate my life for the people, and I always had a passion for law. And in my first internship at the trial court, that was my first court experience, and I saw the working of the judge, and from there onwards, I think the journey began for me. And I thought that this would be a perfect combination where I have a dedication for law as well as for working towards the society for the people.
There are a lot of the ways to serve the society, no? Like, for becoming a judicial officer, you thought कि ठीक है we I need to serve the society, I want to do justice, but there are a lot of other ways you can go for litigation, advocacy, but why specifically judicial officer? Like एक बार internship करके या एक बार उनको देख कर आपको ऐसी जो है फील आई कि आपको जुडिशियल ऑफिसर बनना चाहिए?
Ma'am, with respect to litigation, I I do not have much interest in litigation, and I think that doesn't suit my nature and my law area of interest. As far as a judge is concerned, he is there just to work on the basis. He's there to decide the matter on the basis of facts. But as an advocate, I have to represent people, and I have to represent even if within me I am not in their favor, and somewhere that enters my conscience. I believe that is the reason.
Okay, so as per you, what quality does or do a judge should have? आपके हिसाब से वो कौन सी 3 या 4 टॉप क्वालिटीज होनी चाहिए एक जुडिशियल ऑफिसर के पास?
Ma'am, a judge should have integrity. He should have an unbiased mind, and he should have empathy as well, and he should work uh, without any influence, just on the basic law and the legal principles, and to decide upon without any influence from the society. He should be working according to the law. So
Okay. So don't you think so that even we say that we should be unbiased, despite the fact that we keep this thing in our mind that we should be unbiased or we should be very fair enough while delivering justice. But when it comes to our family matter, or when it comes to, or you can say it's a human tendency that you are biased in some cases where your family or your close ones are involved. Suppose there's a case in which you are sitting as a judge and and your family, your very closed one, your loved one is involved in the case. How you will be acting in that situation? Is any provision of Bharatiya Nagarik Suraksha Sanhita which relates with my question?
ma'am, in that scenario, I will recuse myself from hearing the case. As far as BNSS is concerned, I'm not aware of the particular section, but as far as CRPC is concerned, the section is 479, where if a judge has a personal interest in a case, yeah, he should not be listening to the case. A judge should not.
Okay, absolutely
So I
correct.
would do the same.
Huh. Karan sir, Mishal sir, please.
Hi Bhavya, how are you?
Hello, sir, I'm fine.
So Bhavya, you completed your law from NLU Shimla, right?
Yes, sir.
And you are pursuing judicial service examination.
Yes, sir.
You are preparing since
So since 2023,
2023. So this is your first attempt.
this is my second attempt,
Okay,
but
earlier.
I gave first attempt.
Okay,
Yes, sir, in of Himachal Pradesh.
Okay, any
And
specific reason for doing law from NLU? Because there is a culture that अगर आप NLU में जा रहे हो तो obviously back of the mind की corporate firms में जाना है, पैसा कमाना है, right? So why NLU and why judicial services after completing law degree from a prestigious institutions like NLUs?
okay, so my introduction to law was through my father, and it was when that he said that you should pursue, and I also liked it when I first read it, and I developed interest since then. So when we searched for the institutes, I gave exams of multiple institutes involving other traditional universities as well as CLAD. So as a person who wants to pursue law in India, the first choice is naturally a national law school, because that is uh, that that is the most prestigious one in the country. So I got selected here. So overall other institutes, I chose this. As far as corporate sector is concerned, my views for studying law was never getting into corporate or getting into litigation. In the beginning, my core was just to learn law from from the best of the colleges of the country. And after that, after I completed my law, I wanted to pursue judicial services as natural interest towards law as well as for the country. I wanted to do judicial services.
So who is the present chancellor of the Himachal Pradesh National Law University?
So, Chancellor usually is the Chief Justice of the High Court of Himachal Pradesh, that is Gurmeet Santewalia.
So this is for all the NLUs in India, or this is only for the Himachal Pradesh state? That the Chief Justice of the concerned High Court is the Chancellor of the NLU.
So, usually it depends on the law under which the NLU is framed. Somewhere it is the Chief Minister of the state as well.
So NLUs are established by which law? Is it a state law? Is it a central law?
So, state enactment.
State enactments.
Yes,
So
sir.
can you mention the name of the enactment by which the HP NLU established and in which year the NLU Shimla is established?
So, it was Himachal Pradesh National Law University Act 2016.
Hmm.
It was enacted under that.
Okay, okay, okay. Okay. Which subject do you prefer the most?
So, Indian Evidence Act.
Indian Evidence Act, right? So, is there any particular section under the Indian Evidence Act or the Bharatiya Sakshi Adhiniyam which gives you a right to produce the evidences before the court?
Gives you a right.
Yes. Or there is no requirement of any such enabling provision which allows the parties to produce the evidences before the court. This is a constitutional right or a statutory right.
So, as far as the producing evidence is concerned, it is the procedure, and in the procedure, it is itself given that evidence should be produced by the parties.
So is it a statutory right or a fundamental right or a constitutional right
So, statutory right.
where it is mentioned?
So, as far as particular section is concerned, I am not aware whether it is particularly given in the Indian Evidence Act or not.
Okay. Have you read about the inherent powers of the court under the Code of Criminal Procedure or CPC?
Yes, sir.
Okay. Is there any similar section with respect to the same under the Bharatiya Sakshi Adhiniyam or Indian Evidence Act?
Inherent powers
Yes.
of the court.
Yes.
No, sir. I'm sorry. I'm not aware.
So suppose you are selected as a judicial officer, right?
Yes, sir.
As per the Bharatiya Sakshi Adhiniyam or Indian Evidence Act, have you the powers to ask any questions to any party, to any witness, whether the question is
Yes.
relevant or whether the question is irrelevant?
Yes, sir.
Okay, under which section?
So 165.
165. And the judgment you are eventually passing on those questions that are relevant or irrelevant, that judgment is based on only the questions which is relevant or irrelevant, or both?
So only relevant questions.
On irrelevant questions, right? So what types of presumptions are there in Bharatiya Sakshya Adhiniyam?
So there are three types: may
Okay.
presumption, shall presumption, and conclusive proof.
Can you bifurcate these three presumptions?
Yes, sir.
The exact
So
the exact words which are mentioned in the Where Act.
exact words. Okay, so I'll give it a try. Section 4 deals with the presumption clause. May presumption deals, it says that the court, if a matter, if a particular section says that there is a may presumption, the court can allow evidence for it or can accept the fact as it is unless it is rebutted. For shall presumption, the court can allow further evidence to rebut it, but the presumption is a bit stronger than may presumption, and it usually follows the court usually follows it unless it is rebutted. As far as conclusive proof is concerned, if the fact is if one fact is dependent on the other and one fact is proved, the other fact on the proof of the first fact will be considered as a conclusive proof, and no further evidence in rebutting that particular fact will be allowed.
Fine. So, what are the major changes are there in the new Bharatiya Sakshya Adhiniyam which replace your earlier Indian Evidence Act?
So, first of all, some sections were consolidated in one. For example, the provisions of confession and the exceptions they are consolidated in one section, and the promise or inducement in the confession they are also consolidated. Then
These, these
provisions
are
related
these
to
are
exception.
these are the same provisions which are there in the Indian Evidence Act, right? So I am asking you, what
Yes.
are the new concepts or what are the new provisions which are added in the Bharatiya Sakshya Adhiniyam?
Regarding the electronic evidences, the admissibility,
So
the
electronic evidence
provision.
is already there in Indian Evidence Act.
Yes, sir, it is already there. But the confusion was regarding the admissibility. It was looming and it was
Can you can you can you
clarified.
can you cite me the landmark judgment on admissibility of electronic evidence, which
Yes,
is
sir.
related to state of Himachal Pradesh?
Respect to state of Himachal Pradesh.
Is there any landmark judgment with respect to admissibility of electronic evidences?
Yes, sir. So the final judgment was of the Supreme Court in Arjun Pandit Rao Kotkar versus Kailash Kushan Rao Bonsral in 2020. It actually overruled the judgment of Himachal Pradesh. Um,
And the name of that judgment?
so I am not able to recall the exact name, but it was Himachal. It was
But
some
Bhavya,
Muslim name was there.
you said that Indian Evidence Act is your more favorite or preferable subject. You must know each and everything when you are saying that this is my favorite subject. Right.
Okay, sir.
Thank you, Bhavya. Vishal sir, please.
Hi, Bhavya. First
Hello,
of all,
sir.
I would just like to know your life interest and hobbies in general.
So my hobbies are usually I draw, I paint whenever I get time. Usually I paint mandal art and kalamkari arts, not in the authentic way, but uh, a twist of my own. But the inspiration is mandal and kalamkari art. And
Okay,
other activity.
please continue. Other activities?
So so sometimes I like to cook. Sometimes I like to hear some folklores which have spiritual and meditative and life lessons significance. So that get me inspired.
Okay. Could you please point out key changes which have been introduced by the Bharatiya Nagarik Suraksha Sanhita?
Key
Any
changes.
five. Any five.
Okay. So one change was with respect to the FIR. Now you can file a zero FIR from anywhere. It can be through electronic means, via email or a message. Then another would be change in investigation. While search and seizure and investigating photography is now compulsory. Then another would be the forensic search, where imprisonment, the offences where the imprisonment is above 7 years, the forensic investigation is necessary. Then
Necessary, mandatory, you mean?
yes, so mandatory. Then there is the Directorate of Prosecution. First time the responsibility has been placed on the prosecutors, the Directorate of Prosecution, in deciding the matter in a time-bound manner to check whether the trial has been speedily disposed of or not. And last would be um, the time-bound manner of completing the investigation and the judgment. Uh,
What time
that's
limit has been set up for making an application for discharge?
so specific time-bound limit I am not able to recall right
Okay. Have you heard anything about the victim protection scheme?
now. Yes, sir, I've heard about it.
Tell us something.
Mm. So, in that scenario where the victim is vulnerable, the case is of such a nature that victim requires protection, requires medical attention that would be given to the victim at the
Any
expense of state.
particular statutory provision you would like to cite? Any particular section?
I'm sorry, sir, I'm not aware of that.
Okay. Um, any new offenses which have been introduced by the BNS?
Yes, sir, there are few offences. One would be the petty organized crime, then there's organized crime. Definition of terrorism is there, offense has been described. Then in section 69, a new offense has been created where the sexual intercourse by deceitful means.
Bhavya, my next question is, what is a new form of punishment which has been introduced in the BNS?
So community service.
Has it been defined anywhere in BNS?
So it is defined in BNSS.
Which particular section?
So I'm not able to recall the section, but it is there.
What do you understand by the term community service?
So the persons who are now convicted under certain offences, they would be liable to be served, and for that they would not get any remuneration. It is um, a restorative kind of punishment, and it is away from the retributive form, and it is considered as more progressive and more justice oriented when we talk about the convicts.
Can a chief judicial magistrate give this community service as a punishment?
Yes, ma'am.
Sure.
I'll check.
Check on it. Continue. And can you relate any recent movie with this? Any recent movie you have heard about in which community service was given?
No, I'm not
No
aware about
interest in movies?
not much, ma'am.
Not a
You
problem.
should definitely watch Sitare Zameen Par.
Yes, you
It
will
is
relate
completely
with that.
based on community service.
Okay,
Anyhow,
sir.
who is the Union Minister for Law and Justice presently?
Mm, so, so I'm not able to recall the name. I've read it.
No worries. Okay. Could you tell us about the provision for maintenance under the BNSS?
Sir, I have not memorized the section number for BNSS, but I know
But have you read the new provision?
um I
It's
haven't
okay.
read.
I understand you don't recall the section, but are you aware? Is there any substantial change from what we already had in CRPC and what we now have in BNSS?
No, sir, I'm not aware of maintenance section any difference.
Okay. Could you point out the difference between section 125 of CRPC and the maintenance provision under the Hindu law?
Under HMA, Hindu Marriage Act.
HMA, yeah, HMA as well as Hindu Adoptions and Maintenance Act.
Yes, sir. So, as far as Section 125 CRPC is concerned, it is a summary procedure, it is a summary trial, and there is no need to to prove that the marriage is valid between two persons. Marriage should be valid, but it should not. There is no requirement of compulsorily proving it to get maintenance under 125. As far as Hindu Marriage Act is concerned, the maintenance procedures start after the separation, and it is for divorced women. 125 is also for divorced women, but it is a final provision after getting separated under any of the decree under HMA, and it is full and final and
So
full
there is
fledged.
there is no provision for interim maintenance under the HMA. You mean to say that?
इंटरिम मेंटेनेंस का प्रोविजन है सर HMA के
So
अंदर.
you only said you can claim it after divorce, after everything is finished, there is some decree.
Sir, regarding the final maintenance, interim maintenance can be provided. And interim maintenance
Okay.
provision is there in 125 as well while the proceedings are going on.
So what is the point of difference?
Sir, it is a summary proceeding when you need early or when you need urgent maintenance and the proceedings are already going on or under HMA or HAMA. So in that scenario, 125 can be used. For HAMA, the provisions are for married women who are living separately or with the husband being neglected. So
So
this is the
being
difference.
neglected is the only ground under HAMA?
No, sir. Can be the women may be neglected or may be separately living under reasonable causes in that scenario as well.
Have you read about the 130th Amendment Bill, Constitutional Amendment Bill?
Yes, sir.
Tell us something about it.
So the 130th Amendment Bill deals with the disqualification of the members of the ministers, especially whether the Prime Minister or the Chief Minister or the Council of Ministers, in case that they are in jail for a serious offense, which punishment goes up to 5 years, and they are not able to get bail within 30 days.
Okay. Thank you, Bhavya. All the
Okay, so
best.
we'll love to ask you a few more questions and then we'll give you the feedback, right? Let's talk about CRPC. Are you comfortable with CRPC?
Yes, ma'am.
Okay. So, for example, a person is arrested, okay, by police officer, and we all are aware कि 24 घंटे के अंदर we have to present him before magistrate, right?
Yes, ma'am.
Investigation is not completed. Police has not done the interrogation well within 24 hours. Then, while producing before the magistrate, if police wants police custody, what else or what other thing he need to present before magistrate? Like magistrate सिर्फ एक्यूज को देखकर डिसाइड करेगा कि पुलिस कस्टडी देनी है, जुडिशियल कस्टडी देनी है. What will be the factors which will decide whether to give police custody or judicial custody? How he will decide it?
Yes, ma'am. When we talk about Section 167 CRPC deals with default bail. and if the investigation is not completed in 24 hours, then the police can go for police custody. And the factors would be if there are any reasonable grounds, if there is reasonable suspicion or there is credible information, and the
No,
police
my dear,
require.
you didn't understand the question well. I'm asking when a accused will be presented before magistrate. How will the magistrate decide whether to give a police custody or a judicial custody? Which factors will he consider? मतलब सिर्फ accused की शक्ल को देखकर तो नहीं decide करेगा कि इसको पुलिस के पास भेजना है या जेल में भेजना है, जुडिशियल कस्टडी में भेजना है. तो
Yes,
हाउ
ma'am.
यू डिसाइड? मजिस्ट्रेट, आप मजिस्ट्रेट हो गए, आपके सामने अपराधी आया है और अभी इन्वेस्टिगेशन कंप्लीट नहीं हो पाई है, तब आप कैसे डिसाइड करेंगी?
Ma'am, factors would be whether there is any need for interrogating the accused for any further information or discovery,
How
or
you'll get to know that? What you will
ma'am,
check? एक्यूज सामने खड़ा है, उसको जेल में भेजना है, पुलिस कस्टडी में, क्या चेक करेंगी आप? यू
ma'am,
कांट डिसाइड बाय द फेस, राइट, कि नहीं नहीं इसने किया होगा अपराध ऐसा.
ma'am, the nature of the case, the level of the accusations, and the whatever the investigation has been
How?
done,
How you will identify that?
through police
Case diary, isn't it?
case diary. Police diary. I was about to say police diary, but yes, case diary.
It's case diary. So whenever the accused is presented before magistrate, it is the responsibility or duty of the police officer to present accused as well as the case diary. It is written there, isn't it? चलो, ओके. देन अगर मान लो एक एडवोकेट जज को ब्राइब करता है, आपके आप एज अ जुडिशियल ऑफिसर हो और एडवोकेट ने आपको घूस दी है कि मेरे फेवर में जजमेंट दे देना, तो यहाँ पे एडवोकेट ने कौन सा अपराध कमिट किया? घूस खिला दी है जज को. Which offense is committed by an advocate?
Contempt of the authority of judicial officer.
More precise?
I'm sorry.
Not a problem. So, this was all from my end. Sir, if you would like to ask or give her the feedback.
Yes. Bhavya, you come from Paonta Sahib, right?
Yes, sir.
Paonta Sahib is famous for what?
So, Shri Guru Gobind Singh Ji Gurdwara.
Okay. When this Gurdwara is established, in which year? Have you any idea about the same?
So, it has been recently established, but Guru Gobind Singh Ji came in 1600s, end of 1600s,
Okay.
1670 year.
What it means, Paonta Sahib?
So, Paonta Sahib is actually a misspelled name. It was originally Pauntika Sahib, where it meant that this is the place where Guru Gobind Singh Ji stepped and stayed for a long period. The longest period he stayed here. So it was Palm Tikka Sahib.
Okay, can you name the river which is following side by the Gurdwara?
So Yamuna River.
Okay, perfect. Thank you, Bhavya.
Thank you, sir.
So the feedback from my end would be very good. You have performed very well. And the most, I would say, the best part of the entire interview was whatever you are not knowing, you have said it out and out that I don't know. That is the best part, because rather than beating the bush and irritating the bench, it is better that you say that you don't know. That is the most appropriate way. But again and again saying the same, that I don't recall or I don't remember, will give you definitely a negative like point of view. Okay. Moreover, well performed. Brush up your concepts once more before you go for the interview, and I wish you all the best, my dear.
Thank you, ma'am.
Bhavya, from my side, आई ऑब्जर्व्ड यू, थोड़ा सा मुझे ऐसा लगा कि आप कहीं नर्वस हो रहे हो जहाँ आपको क्वेश्चंस का आंसर नहीं पता है. वो आपके फेस के ऊपर शो हो रहा है थोड़ा सा, राइट? तो उसको थोड़ा सा ओवरकम करो, इट्स ओके, है ना? कोई जरूरी नहीं है कि हर क्वेश्चन का आंसर आपको आए, राइट? यू हैव ऑलरेडी परफॉर्म वेल इन योर मेंस एग्जाम। वो आपकी
Okay.
पर्सनैलिटी चेक कर रहे हैं, आपका कॉन्फिडेंस चेक कर रहे हैं। एंड वो बैक टू बैक फायर क्वेश्चंस भी पूछ सकते हैं, है ना। तो उस चीज़ को लेके नर्वस नहीं होना है, कॉन्फिडेंट को लो नहीं करना है। सेटल्ड रहो, काम रहो, अच्छा जाएगा। क्योंकि फेस पे एक्सप्रेशंस चेंज हो गए तो मतलब गड़बड़ हो गया इंटरव्यू।
ठीक है
अरे
सर।
शायद विशाल सर ने कोई क्वेश्चन पूछा था एचएमए का, उसके अंदर आपकी आंखें ऐसे घूमने लग गई थी, थोड़ा सा बॉडी मूवमेंट भी स्टार्ट हो गया था। वो
ओके।
शो करता है कि भाई कैंडिडेट अब जाने वाला है। और फिर वो बैक टू बैक कुछ ऐसे क्वेश्चंस पुट करेंगे, पूरा ही इंटरव्यू आउट ऑफ ट्रैक चला जाएगा, है ना। एंड व्हेन यू आर सेइंग कि मेरा सब्जेक्ट इंडियन एविडेंस एक्ट 6 है, मैं उसको प्रेफर करती हूँ, तो बेटा इंडियन एविडेंस एक्ट तो बहुत अच्छे से पढ़ के जाओ फिर। वो एविडेंस एक्ट ही कर रहे हैं सारा दिन बैठ के वहाँ पे,
ठीक है सर।
है ना। और वो जो जजमेंट है वो सफ़ी मोहम्मद, जो बहुत फेमस जजमेंट है, सफ़ी मोहम्मद वर्सेस स्टेट ऑफ हिमाचल प्रदेश, राइट। रेस्ट यू आर गुड टू गो, नो इशू। जो एनएलयू का जो एक कॉन्फिडेंस होता है ना, जो मूड में आप लोग करते हो एनएलयू में, उस कॉन्फिडेंस के साथ जाना है आपको, राइट।
ओके।
And do carry a smile always.
यस।
It's all destiny now, beta. Up to you'll shine. You will shine. Do not worry. But carry a smile.
Okay. I am not very comfortable with the new criminal laws and the particular section
नो
because it
इशू,
was
नो इशू,
not
आप क्लियर कर दीजिए
process.
वहां पे पैनल में, बोल दीजिएगा कोई
Not a problem, but my dear, now the new laws are implemented. So it might be a chance कि आपसे नए सवाल पूछे जाए. At least the changes, the provision, broadly इतना डिटेल में नहीं पता हो, but फिर भी पता होना चाहिए because now the laws are in existence.
Yes, sir.
सो भव्य, आई थिंक आपके इंटरव्यू में दो चार चीजें बहुत इंप्रेसिव थी। फर्स्टली, यू न्यू अबाउट द वाइस चांसलर ऑफ योर यूनिवर्सिटी, दैट इज अ गुड थिंग। आपको एस्टैब्लिशिंग एक्ट के बारे में पता है, आपको पोंटा साहिब के बारे में पता है। दीज आर द गुड थिंग्स जो आपने काम किया है एंड इट इज विजिबल। आपकी प्रेजेंटेशन इज गुड, ओवरऑल यू आर कॉन्फिडेंट। हाउएवर, आपके इनिशियल इंटरव्यू में जब मैम ने आपसे पूछा कि व्हाई यू वांट टू बिकम अ जुडिशियल ऑफिसर एंड व्हाई जुडिशियल ऑफिसर, व्हाई नॉट सम अदर फील्ड, थोड़ा सा आई वुड से कि आपको वहां पर ब्रश अप करने की जरूरत है, पॉलिश करने की जरूरत है। बिकॉज कहीं ना कहीं आप जो कह रहे हो वो कन्विक्शन के साथ नहीं कह रहे हो, दैट यू ट्रूली वांट टू बिकम अ जुडिशियल ऑफिसर। दिस इज व्हाट आई पर्सनली थिंक कि आपको वो बात अपनी पूरी कन्विक्शन के साथ रखनी है कि मैं शिद्दत से यही करना चाहती हूँ, और एक
Okay, sir.
कन्विंसिंग आंसर देना है। तो उस आंसर को आई बिलीव आपको बहुत अच्छे से थोड़ा सा प्रिपेयर कर लेना चाहिए, थोड़ा सा रिहर्स भी कर सकते हो दो तीन बारे। देन जैसा कि सर ने भी पॉइंट आउट किया कि अगर आप इंडियन एविडेंस एक्ट को बोल रहे हो कि इट इज माय मोस्ट कंफर्टेबल सब्जेक्ट, तो यू नीड टू नो लाइक गुड कंसेप्चुअल क्लैरिटी। जो 165 वाला क्वेश्चन था, दैट वाज अ वेरी बेसिक क्वेश्चन, वो आपको आना चाहिए था। देन जब आपसे प्रिजम्पशंस के बारे में पूछा जा रहा है, तो सेक्शन 4 को आप थोड़ा और बेटर तरीके से प्रेजेंट कर सकते हैं। और प्रिजम्पशंस की बाइफर्केशन को आप दो में भी बता सकते थे, प्रिजम्प्शियो जूरिस एंड प्रिजम्प्शियो ह्यूमनिस। देन द एग्जैक्ट वर्ड सर ने पूछा था कि व्हाट आर द एग्जैक्ट वर्ड, तो आपको वहां पर मे प्रिज्यूम, शैल प्रिज्यूम बताना है, स्पेसिफाई करना है। देन अदरवाइज एवरीथिंग इज गुड। थोड़ा सा जो सर ने भी पॉइंट आउट किया कि कहीं पर अगर आप अटक रहे हो, इंस्टेड ऑफ बीटिंग, आपने कोशिश अपनी तरफ से यही करी कि आपने मोस्टली जगह पर बोला कि मुझे एग्जैक्ट प्रोविजन नहीं पता या फिर आई हैव नॉट रेड इट। दैट इज अ गुड थिंग, बट रेपिटेटेड जब यही चीज आएगी तो कहीं ना कहीं वो थोड़ा सा नेगेटिव हो जाएगा। आई वुड सजेस्ट, अगर आपके इंटरव्यू में अभी दो चार दिन का समय है, तो थोड़ा सा सिर्फ की चेंजेस विच हैव बीन इंट्रोड्यूस्ड बाय द न्यू लॉज, सिर्फ उनको देख लो। आई एम नॉट आस्किंग यू टू रीड द एंटायर बैरेक्स, नॉट एट ऑल। कहीं आपको ऑनलाइन कोई वीडियो मिल जाए जहां पर उन्होंने की चेंजेस, क्या क्या नए ऑफेंसेस इंट्रोड्यूस हुए हैं, क्या क्या न्यू प्रोविजंस इंट्रोड्यूस हुई हैं। फॉर एग्जाम्पल, आई आस्क्ड यू डिस्चार्ज एप्लीकेशन कितने टाइम के लिए, तो वो जो टाइम लिमिट्स उन्होंने दिया है, इट इज वेरी इजी टू रिमेंबर, मोस्टली 30 डेज, 60 डेज, 90 डेज, यही तो है।
ठीक है
तो
सर।
वो थोड़ा थोड़ा भी अगर आप उसको कर लोगे, नॉट एवरीथिंग, जस्ट 5 to 7%, 10% अगर आप पढ़ लोगे, दैट विल गिव यू एन एज। कोई और कैंडिडेट जब आकर वही इंफॉर्मेशन बता देगा और आप नहीं बता पाओगे, तो वो कहीं ना कहीं आपको एक नेगेटिव जाएगा। फॉर एग्जाम्पल, मेंटेनेंस का प्रोविजन है, इट इज सब्सटैंशियली द सेम, यू जस्ट नीड टू रिकॉल दैट इट इज सेक्शन 144 नाउ, इट इज नॉट 125। ठीक है, ऑल द बेस्ट, विश यू लक।
Thank you, sir.
आपने अपनी सब्जेक्टिव नॉलेज, ऑब्जेक्टिव नॉलेज उनको पोर्ट्रे की है। नाउ इट इज टाइम टू पोर्ट्रे योर कॉन्फिडेंस, द कन्विक्शन दैट यू वांट टू बिकम अ जुडिशियल ऑफिसर। फुल कॉन्फिडेंस के साथ जाओ, डोंट वरी, have faith in your hard work, and it will definitely come to you. All the
Okay.
best.